video, we're going to look at misrepresentation. This area of law is about statements made during negotiations. Some of those statements will become terms of a contract, and if that's the case, you can sue for breach. So the following examples are statements which we believe have not become part of the contract, and therefore our only option to sue on them is to prove that they're a misrepresentation. So I've got a series of examples here based on a sale and purchase of a house, and we'll come back to these. So they illustrate the various types of statements which create problems for us. So let's just go down through, and we're going to have a look at the notes which are on Canvas relating to misrepresentation. Now, the first issue with misrepresentation is where we find the law. Now, in misrepresentation, we kind of jump between common law statute and common law. The common law tells us what a misrepresentation is. So this has come from the various cases, so you won't find this in the statute. You simply have to work through what the precedents say, which is below. Once we have a misrepresentation, we go to the Contract and Commercial Law Act, and it gives us our rights to remedies. And these are damages for any costs or losses caused by the statement, and it might give us the right to cancel, so we can get out of the contract if it has a substantial effect, or as we'll see, we agreed it essential. What it doesn't tell us is how much we get paid, and for that we go back to the common law, and we'll cover that when we look at the area of remedies. So we have a stepwise approach to this. Our starting point is to ask the question, do we have a misrepresentation? And we know that a misrepresentation is a false statement of fact. Now, this word fact, facts are statements which can be objectively verified. What that means is there is some way of proving them right or wrong. Now, what's below here are a list of situations from the cases which are not normally misrepresentations because they're not facts. However, the courts have provided a set of exceptions where you can sue for these statements. The first is business puffs, and these are outrageous exaggerations that nobody in their general thinking would possibly believe. And so it can't mislead them, and they're not considered to be misrepresentations. The second are opinions. Now, opinions are what you believe to be true. Now, that is not going to be a statement you can be sued on unless the exceptions apply. So if an opinion is an expert's opinion, and that could be someone we consider an expert through their knowledge, experience, qualifications, or somebody who simply worked in that area for a long time, or works for a business, then their opinions can be misrepresentation. So this could be an issue for you when talking about staff making statements to clients and staff making statements to suppliers potentially. Then we have statements of intention and statements about the future. So these are both about what's going to happen. And misrepresentations are considered statements of present fact. Therefore, statements about the future are not normally a misrepresentation unless they are like opinions not honestly made, or they imply something about a present fact. We'll look at an example. The final set of circumstances which are not normally misrepresentations is silence. So the rule is that I don't have to tell you anything, including telling you that what you think is actually wrong, unless you ask. Now again, there are numerous exceptions to this in other areas of law. However, as a general statement of contract law, I don't have to tell you things unless you ask. The exceptions to this include a half-truth, which is a statement which is true, but it implies something which is false. We'll look at an example. Statements which are false after you made them, so it's true when I made them, but before we sign a contract or enter an agreement, they become false. Fiduciary relationships, the parent-child, trustee, beneficiary, solicitor, client, we looked at an undue influence. These people have an obligation to look after the other person and therefore cannot simply stay silent. The final one down there is this idea of Uberima Fides, contracts in good faith. So your insurance contracts are a good example of this. You have to tell the insurance company everything which is relevant, even if they don't ask. So let's take this set of exceptions and our definition up to our list. And our question to start with is, are any of these actually simply facts we can prove right or wrong? So it's a 4-bedroom house, when in fact it's a 3-bedroom. This could arise where a person is selling the house and the house has 4 rooms used as bedrooms, but one is a sunroom. So the buyer thinks they're buying a 4-bedroom house. They go to the council to check the records and they find it's actually 3 bedrooms and 1 room is a sunroom. So they want to cancel the contract. Now, is it a misrepresentation? Absolutely, because the question of 3 or 4 bedrooms is a fact. It can be proven right or wrong. The second example there, good schools. This is definitely opinion. Now, if a person has no knowledge of the school whatsoever, then that's not an honest opinion, it's simply a guess. So your opinion must have some reason behind it. The garden should grow excellent fruit trees. Well, we can get experts to test the soil, so we could prove that right or wrong. So that is a statement of fact, and if it's wrong, it's a misrepresentation. Neighbours are excellent. This is very much opinion. These neighbours hold a lot of parties, but the seller likes the parties, so they think they're excellent. Whereas other people would not consider noisy party neighbours to be excellent neighbours. They, whoever they are going to put high-speed internet on the street. That's a statement about the future. Now, if they don't actually believe that, they just made it up, then it could be a misrepresentation. But very hard to sue someone for statements about the future. This last, the question by the buyer, has crime been a problem for you? No, we haven't been burgled in 10 years we've lived here. And that statement is totally true. So there's no dishonest statement. But the buyer listening to that statement is led to believe that the street has a low crime rate or has no issues with burglaries, when in fact the opposite is in fact true. 15 houses burgled in the street in the last 2 years is quite a high crime rate. So this is a half-truth. The statement is true, but the implication is false, and therefore we could sue on that. So what are we going to do with this? We've identified some of these as misrepresentation. We're going to go to our remedies and look at compensation as damages and can we get out of the contract. So let's go back down to our notes. So step 1 we've gone through, identified our misrepresentations. Then we're going to go to the Contract Commercial Law Act 2017. Section 35 will give us damages if induced. Now the word induced means influenced. It's a reason for you to enter the contract. So in those statements above, are people induced by these statements? Well, 4 bedrooms, clearly yes. Good schools. Any of those could be considered reasons to enter the contract, particularly the ones that have been asked about. When would we not be induced? And the answer to that is when we don't rely on the other person. So if I had asked the question about good schools and then gone to the schools and checked up with other people and also checked the records that are available, I'm not relying on that person. If I was buying a house and they told me all about the house and I had a builder do inspection to determine if it's actually a good house, I'm not relying on the seller, therefore it's hard to sue them for misrepresentations. If I buy a car and I get the AA to check it out or a mechanic to check it out, then I can't rely on statements by the seller saying it's got a good engine when I've had a qualified mechanic actually check the engine. So I have to have relied on it to say that I'm induced by the statement. Now when we look a little bit lower and we look at cancellation, it's the same with another step. So we have the same issue for inducement, but we have an and that is one of the criteria in that section to be met. So let's turn to that section. So we're in the Contract Commercial Law Act 2017, damages for misrepresentation, and here you can see that it says a party has been induced by a misrepresentation. Notice it says innocent or fraudulent, so it doesn't matter whether you believed what you said, it's a question of whether it's wrong, apart from dishonest opinions of course, made by a person or on behalf of another party. So the seller or their real estate agent make the statement, we can still sue, provided we can work through those 2 points, induced by the misrepresentation. Then we're entitled to damages. And that's all we need to say with that section. We get damages, and that's compensation, and we need to calculate it. Now where we go next is to turn to section 37. We're going to look at, can we get cancellation? So can we cancel the contract? Well, as I mentioned earlier, the first step is the same. Induced by a misrepresentation made by or on behalf of another party to the contract. My line's a little messy there. So that's exactly the same issue. Now, the additional part is that that section applies if and only if they have agreed the truth of the representation is essential, expressly or impliedly, or the effect is to substantially reduce the benefit, substantially increase the burden, or make the benefit or burden substantially different. Right, so our process here we can just summarize pretty quickly. We need inducement, we need it to be an essential term agreed or a substantial effect, and we can cancel the contract. So let's go back to our list and see what we can do with these. So our first one up here, 4-bedroom house, we know it's misrepresentation. Did it induce the person? Well, a reasonable person would rely on this, so yes. Will we get damages? Well, 3-bedroom houses are worth less than 4 bedrooms, so yes. Is that going to be a substantial amount? Probably yes. Therefore, we could cancel the contract. Fruit trees. Does that affect the value of the house? Now, we decided it was a misrepresentation because it's wrong, and we've checked with experts it doesn't grow fruit trees. And so we asked the question, how much damages? Well, that would be difficult because will a house that grows fruit trees be more valuable on the market to not growing fruit trees? And the answer might be very little, in which case we might get some damages, but we won't get cancellation unless the buyer had said, I'll only buy this place if it'll grow fruit trees. Then it would have been agreed essential. This half-truth, a crime being a problem for you, no, but omitting the truth that there's 15 houses burgled, that would have a substantial effect on the value. So the damages could be significant and the cancellation would also be available so the person could get out of the contract. Now that's pretty much as far as we go with misrepresentation. Just to note a couple of other things about it which are in the Act. And that is, contracts may have terms that say you haven't relied on any statements made in negotiations. So we could have all these statements leading up to buying and selling the house, but we put a term in our contract saying you haven't relied on us. Now the point about that is this relied part. If you say you haven't relied on us, then you cannot say you've been induced by the statement, therefore you can't get damages or misrepresentation. Now the reality of this is the courts don't like these terms. So they have a section 50 which specifically covers the question of having a provision purporting to prevent from the court inquiring into and determining whether a misrepresentation or representation was relied on. So that's exactly what we're talking about with that example. And what it says is the court is not prevented unless the court considers it fair and reasonable. So essentially, if we had people in business negotiating contracts and they're well advised and experienced and they put a clause like that in their contract, the court will enforce it and won't listen to arguments about misrepresentations. But they never consider it fair and reasonable in purchase and sales of house and more consumer orientated areas. So largely we ignore them. Them being the clauses, not the court, of course. And finally, the other point made down here is about what are known as liquidated damages clauses, clauses in contract that set out the remedies so the parties agree how much to pay each other for breach of contract or misrep, and we'll cover that later in the course. Now the rest of this document is a diagrammatic representation of exactly the same areas for those who prefer to see it more visually. And today we'll just finish with a picture of the port area, Napier, on a pleasant autumn afternoon.